Good morning, my lords. I appear for the appellant together with my friends Muniapile and Wong. Respondents are represented by my learned friend Mr. James QC, assisted by Ms. Duma.
Thank you. Good morning.
I thank you, my lords, for acceding to the request of my client for an expedited hearing, as it concerns the fundamental constitutional rights of my client and those of all adult citizens of the Republic of Mauritius. Prior to starting, my lord, I wish to point out that some pages are missing in 3 authorities, and 1 authority has been missed out during the binding exercise. I would pray for leniency from the board, and I will refer to them as and when I go along my submissions. My lords, my submission will be divided into 4 parts.
Remember to keep your voice up.
Yes, my lord.
Well,
I take
yes, both the microphones are working, so that if you speak into them, that should do the trick.
Yes. Sorry. My lords, my submission will be divided into 4 parts. In the first part, I shall be dealing with the right to liberty and freedom of movement. In the second part, the right to protection from inhuman and degrading treatment, as well as protection of the law. In the third part, the right to privacy. And in relation to the 4th part, I shall address the board in relation to the denial of a fair hearing to the appellant, as well as the wrong approach of the Supreme Court.
So the 4th point is denial of
fair hearing by the Supreme Court of Mauritius.
And wrong approach of the Supreme Court.
Yes. And you'll bear in mind that we've read the helpful cases and, of course, the judgment and other papers.
I take note, my lord. There are other issues such as the control of constitutionality, interpretation of the Constitution, and the concept of reasonably justifiable in a democratic society. That is the concept of proportionality. This will be dealt along when during my submissions. Right? They are interlinked.
Yes, you can probably keep submissions on those areas reasonably short, since we deal with public law in this court or in the Supreme Court almost every day, so we're reasonably familiar, I hope, with the concepts.
My lord, there is one issue which we have raised during our submissions before the Supreme Court. That is, subject to the Constitution, Parliament shall make laws for the peace, order, and good government. In relation to that issue, our complaint was that the legislation was passed with a certificate of urgency, bypassing the Public Procurement Act, awarding the project to Singapore at 4 times the cost, which in my client's view was a waste of resources, in view that, according to him, basic commodities such as water, citizens of Mauritius in various spots have only 1 hour access per day. Though this argument may be a very powerful emotional argument, I propose to drop same. I'm dropping same.
Right.
My lords, prior to coming to the first issue, it is my humble submission that the concept of human rights is a universal concept. Constitution, the Constitution of Mauritius, Constitution of other countries, covenants and conventions do not create those rights. They merely recognize or assert those rights. That is, one cannot say that a Mauritian citizen will have lesser fundamental rights, basic fundamental rights, than a European citizen. There has been the issue about Section 3, that is, support can be gathered from Section 3 of the Mauritian Constitution, which is to be found at tab 21, volume 1. Tab 21, volume 1. And it is on page 1389. The opening sentence is, "It is hereby recognized and declared that they have existed and shall continue to exist," and it goes on. Now, coming to the first issue, that is the right to liberty and freedom of movement, guaranteed under Section 1, which states that Mauritius shall be a sovereign democratic state. Section 3A, Section 5 and 15 of the Constitution. We shall be dealing with these provisions of the Constitution together. It is the humble submission of the appellant that the National Identity Card Act infringes his right to liberty and freedom of movement under those provisions. My Lord, if we have a look at tab 5 in the first volume, the National Identity Card Act, and if we have a look at pages 1134 and 35, which reads, "Production of identity card." Reads, if I may, my Lord, "Every person may, in reasonable circumstances and for the purpose of ascertaining the identity of another person, or where he is empowered by law to ascertain the identity of another person, request that other person to produce his identity card where that person is a citizen of Mauritius." And it goes on to say that where a person is required to produce his identity card in accordance with subsection 1, B, he shall forthwith produce his identity card to the person making the request, or where he is not in possession of his identity card, produce his identity card within such reasonable period to such person at such place as may be directed by the person making the request.
Was this an entirely new provision? Subsection 1A, was that an entirely new position in 2013?
I understand if we read at the next page, it goes on to say where the person is required to produce evidence of identity, it shall be sufficient. And then in brackets, that section has been amended, Section 7, by Section 2C of Act 18 of 2003. It is my reading that paragraph 1, capital letter A, has been has come into existence by virtue of Act 18 of 2013.
So before that, was there no subsection 1?
Before that, there was only Section 7, subsection 1, not 1 capital letter A.
So where is the 2013 Act? It's, I was looking at it before I came into court, but just remind us.
Is it tab 24?
Yes, it's tab 24, that's right. which adds those words or changes that section. Yeah, 1411.
Yes, ma'am. It is indeed tab 24. At page 1412. So it is.
So before that, was there no obligation upon the individual to produce an identity card at all?
I understand there would have been no obligation.
No obligation at all?
Well, it looks as if without 1A, it might have been inferred from a statutory right to request the production of an identity card that there was a statutory obligation to comply with that request.
Comply with it.
In both cases, so that in the, 1A may be thought to reduce the scope rather than increased it.
My Lord, it will be my respectful submission that the whole of Section 7 of the NIC Act infringes the right to liberty and freedom of movement of the citizen. I say
That
so.
depends upon what obligations there are.
Lords, I hesitate to interrupt. We do have the original form of the Act.
That would
I
be
can have it
helpful.
copied if necessary.
Can we?
I'm not sure if I've got a sufficient number of copies of it. But Section 7.1 did require, or did permit a person in reasonable circumstances, and for the purposes of ascertaining the identity of another person who is a citizen of Mauritius, request that other person to produce his card.
Well, was there any sanction?
No.
So how does it differ, the new version?
Well,
Is it B that's new rather than A?
I think it's effectively...
Well, let's see the document.
yes, I think... I'm sorry if I have...
We can get it copied.
Yes, I'll arrange for it to be copied. Haven't got more copies on that. No, I'm sorry. No copy.
Yeah.
We can have it copied. Otherwise, it's very odd.
Yes?
Yes, ma'am. My Lord, it is our submission that this section, Section 7, together with its amendment, would infringe the right to liberty, freedom of movement of the citizen. Because as is couched Section 7, any person may stop any person just for the mere purpose of ascertaining identity, require him to produce his card. And should that person fails to have his card, he must give an undertaking to produce same at the request, time and place specified by the person making the request.
Only
in
any
sub-
person.
Only in B.
It's only 1B.
1B would
1B only. You have to be empowered by law to ascertain the identity of the other person.
I would understand 7.1b would refer to a police officer, a person empowered by law.
Yes.
So the 7.1a would refer to any citizen.
Yes.
7.1b.
What does 7.1a add to common sense? Anyone can ask to see evidence of identity, and unless there's a sanction for failing to supply it, the person asked can refuse. There may be consequences. You may not be prepared to do business with someone who hasn't identified himself properly, but that's a different matter. You're not obliged to do business with anyone.
That would always be the case under the general law, even without a statute.
The legislature has provided for offences for non-compliance
Yes,
with
but
any
is there an offence in relation to A?
That is, offences are provided under tab 5,
Which is the provision?
1135.
Yes, it's
Section 9
Section
of the National
9.2 says that every person who contravenes this act
Yes.
or any regulations shall commit
This is to the
an offence. But the point that's being made to you is that 1A only applies, the obligation under subsection 7.1a only applies when the request comes from someone empowered under 7.1b.
It would say that it would apply to any person in reasonable circumstances for the purpose.
No. A is dealing with the request. It is simply saying that it is not an offence, for example, to request. So if I'm a shopkeeper or an innkeeper,
Yes.
I am entitled to ask you to produce your identity card, if I want it, for example, in order to be sure I can do business with you, accept a cheque for you, admit you to my inn. But that's a provision relating to the request. There's nothing which says that it's an offence to refuse the request.
It would, the reading of section 9, subsection 2, any person who contravenes this act, that is, any person who fails to produce.
No. It
I
doesn't.
tell.
It doesn't say that. Where do you find a?
This is subject to my laudable assumptions point, that in its original
Well, that's
state,
obviously changed.
before the subsection 1A was, capital A was added, the position might have been different,
Yeah.
on the basis
Yeah,
that
well, we're
one might
dealing with the,
imply such.
Under the present Act, it's perfectly clear that the only obligation to comply with the request arises when you're asked by somebody who is empowered by law. There's no obligation to comply with the request if you are not empowered by law.
Now,
Yes, sorry. Now, what's your point?
my lord, it would appear that from section 7.1a, any person in reasonable circumstances, and from section 7, subsection 1b, where a person is empowered by law.
Yes. Yep.
So, in my reading of section 7.1b would apply to police officers and to any citizen. Now,
To B. This is B.
2b would be 7.1b would apply to any police officer empowered by law.
Yes.
And 7.1a, any citizen can require production.
No.
Request.
And request.
Yes.
But there's no obligation to comply with it.
Where does it say
Any
in this
person
Act?
can request.
Yes.
Where does it say in this Act that if a person under A, in reasonable circumstances, requests, where does it say that the person he's asked for identity has to comply?
So it provides an obligation to produce forthwith the ID card.
Not
No,
under A.
that's B. That is, and I think you've got to recognise.
capital.
Let me just say, you've got to recognise that 1 capital A deals only with subsection 1B. Now, does that, since 1 capital A imposes an obligation on the person to whom the request is made,
Yes.
is that not further confirmation that 1 little a does not impose any such obligation?
My lord, this will pose the question whether what would be the non-compliance if the request emanates by virtue of 1A.
Yes.
So it will,
You make a request under little a, and the recipient says, I'm awfully sorry, I'm not going to give you the
it
information.
will be,
Yes. And what's your answer?
Yes.
What is the position if there's a request under 1 little a?
yes. In my humble submission, this would imply that
Yeah,
this
well,
act has not been complied with and therefore the person is liable for sanctions.
Well, I think we've got the submission, and I think you've developed it sufficiently. And I think if we mustn't spend excessive amount of time on each point. It's a short point. We've got the point.
Yes.
That's your submission, and I think you can probably move on.
And in addition to that, I would point out that the terms reasonable circumstance has not been defined. And it is my humble submission that exceptionally, even the police can only stop a person when there is reasonable suspicion of that person having committed an offense.
Well, that depends upon the terms of the law, which empowers the requester under little p.
And this is what has been provided under section 5(1)(a) to k of the Constitution. That is, there are limited circumstances when a person can be deprived of his liberty. But prior to that, if I can be allowed to make the connection, a person being stopped and asked to produce his ID card, this would amount a deprivation of liberty. For instance, a person...
Wait a minute, why? Yes, you're going to say, I'm sorry, I shouldn't have interrupted. Carry on, yes? Why will it amount to deprivation of liberty?
Because liberty, that is, the person should be allowed to be free to move around uninterrupted. If a person leaves work or leaves home for work, technically can be stopped and required to produce his ID card as many times, be it by a citizen, be it by a police officer. So this section has been couched in very vague terms. And any lady walking on the street can be stopped by any police officer and be required to produce her ID card. And I draw the analogy with this section and the former section 6 or 10 of the National Registration Act of the UK in 1939, which was a subject matter of analysis by the House of Lords in the case of Wilcock versus Merkel. Same has been reproduced extensively in the Appellate's case, and submissions were offered for the Supreme Court. What the House of Lords had to say that this legislation was passed during war times, and the House of Lords, Lord Goddard, had said that this legislation, that is, the police should refrain from making use of their powers to stop persons under that legislation. Unfortunately, as is obtained with due deference in the UK, that is, there is parliamentary sovereignty, they had to wait for Parliament to intervene and to do away with the National Registration Act. And tab 21, tab 25, the speech of Mr. Cruikshank, the first paragraph.
Yes. Well, I don't really think we're going to get much assistance from the abolition of the requirement under the National Registration Act to produce a national registration or identity card when requested or when required by a constable in uniform. That provision expressly imposed a duty to produce it on the person requested. It said a constable in uniform may require a person to produce the card to him, or if the person so required fails to produce it when the requirement is made, to produce it within such time and at such place as may be prescribed, etc. So that is an express requirement, whereas here the only provision is entitling someone to request production. There's no requirement to produce.
As per Section 1, capital letter A, the obligation is to produce.
Yes,
full-
I know, but we're going back to, that relates to constables, etc., 1 little b. We're not talking about them, are we? Or is your current submission about deprivation of liberty related to requests by constables?
Yes. And requests by police officers as well. In the absence of reasonable suspicion, they cannot stop an individual and ask for production of the card.
Yes, I see.
And
Well, it might be an interference with liberty, but not a deprivation of it.
And reasonable circumstance in the ID code has not been defined. What is reasonable circumstance? Whereas reasonable suspicion would exceptionally allow a person to be arrested and or deprived of his.
I mean, the difficulty about your submission is that it would completely change the ordinary operation of the criminal law. People are requested by officers to answer questions in all sorts of circumstances.
Yes.
People are actually even kettled by the police in Trafalgar Square for a number of hours, and none of that has ever been regarded as a deprivation of liberty. Deprivation of liberty does what it says. On the face of it, asking someone to produce something is not depriving them of their liberty. It's a completely different exercise. If you arrest them,
Yes.
then you're depriving them of their liberty.
My Lord, if we look at the cases of Wilcock versus Merkel and Brown versus Texas, where police officers stop citizens, the case of Wilcock versus Merkel.
Yes, but it wasn't decided on the question of deprivation of liberty.
Deprivation of
It was
liberty.
decided on the basis there was actually power to do what was said, but it was
The argument was.
it was unfortunate it was being done in the way it was or for the purpose it was in peacetime.
If we look at tab 28, my Lord, the case of Brown versus Texas,
Right?
volume 2, at pages
Sorry, tab 20?
1442. 28. Tab 2,
28.
page 1442. My Lord, but prior to coming to reasonable circumstance, regarding the police officer,
But this case is surely against you because it indicates that even where a constable has a power to stop people and ask for an ID card, that power has got to be exercised reasonably.
Yes.
So this is not actually quite such a wide power as the words of the statute read in isolation might suggest. It's much more limited. You've got to suggest that it's unconstitutional even to require the production of an identity card in cases where it's reasonable to do so.
my Lord, if we have a look at section 1, paragraph B,
Yeah.
it has not been mentioned that the police officer will do so in reasonable circumstances or under reasonable suspicion. If we read 7.1b, every person may, where he is empowered by law to ascertain the identity of another person. We don't know whether the police officer is acting under reasonable circumstances.
The reasonable circumstances have got nothing to do with little b, have they?
Well, the reasonable circumstances are presumably something that
Reasonable.
they are presumably something that will, you would say, should be built into the other law, not into this law. If there is a law which empowers a police officer unreasonably to ask for the identity of another person, it's that law which will be invalid, if any law, not this one. This law is not authorising other unreasonable laws, and the normal assumption is that the other laws, which would empower the ascertainment of identity, will be reasonable or will be read subject to, as my Lord Sumption points out, subject to an implication of reasonableness. just going back to Brown and Texas.
Yes.
It's,
Brown versus Texas.
can you just let me put it? It's inconsistent with your suggestion that asking questions amounts to detention, because it was only
Yes,
only
Brown,
after the failure to answer questions that there was a
versus
detention.
Texas, my lord, if we look at page 1446, the last paragraph,
Yes.
it reads, in the absence of any basis for suspecting appellant of misconduct, the balance between public interest and the appellant's right to personal security and privacy tilts in favor of freedom from police interference.
Yes.
And the last sentence, which reads, when such a stop is not based on objective criteria, the risk of arbitrary and abusive police practices exceeds tolerable limits.
Yes. What the court is saying is that when you have a provision like the Texan statute, which authorized a police officer to request a name and address after he'd lawfully stopped someone and requested the information, you read into that a requirement that there should be some ground for stopping and requesting the information. Why don't you assume that that is also what Section 7.1b contemplates? It contemplates circumstances in which there will be a reasonable empowerment by law to ascertain the identity. It doesn't contemplate unreasonable laws.
The legislature has not deemed it fit to say that
Yes, well,
there has been reasonable suspicion, then the police is empowered to arrest,
No, but
detain, to ascertain identity.
But the point in 7.1b is that the police's power doesn't arise from Section 7 of this Act. The police's power arises under other legislation. And we're not looking at the constitutionality of that other legislation.
My lord, along the same line, my lord, liberty has been guaranteed under Section 5 of the Constitution.
yes,
And the restrictions are to be found in Section 5, letter A. If we turn at page 21 and page 1390,
yes,
the situations where a person can be deprived of his liberty has been exhaustively listed by the framers of the Constitution
right,
under letter A to K.
yes,
And nowhere is it provided for the purpose of ascertaining the identity.
yes. Well, that begs the question whether ascertaining identity is a deprivation of liberty, and we've been suggesting to you that it is clearly not. I don't know whether the matter can be carried much further, but
the only support for this proposition can be found in the case of Gillan. That is,
which case is that?
Is a European human rights decision.
Oh, Gillan, yes.
It is to be found at tab 32.
Right.
Volume 2, tab 32.
This is stop and search, is it, or?
Yes. There was a protest and two passers-by were arrested by the police for very little time, 5 minutes to 20 minutes. And the relevant paragraphs are paragraph 55 at page 1542 and paragraph 57 at page 1543. Paragraph 55 reads, the government submitted that the court had never found that the exercise of a power to stop and search to constitute a deprivation of liberty within Article 5 of the Convention. And this is the argument that was put forward by the government. And at page 56, the assessment of the court starts. And at paragraph 57, we can read, the court observes that although the length of time during which each applicant was stopped and searched did not in either case exceed 30 minutes, during this period, the applicants were entirely deprived of any freedom of movement. They were obliged to remain where they were and submit to the search, and if they had refused, they had been liable to arrest and detention at a police station and criminal charges. This element of coercion is indicative of a deprivation of liberty within Article 5.
Yeah. Well, I know, but they didn't decide the point, and it went off mainly on Article 8, I think. But if you look at paragraph 54, this was stop and search,
yes,
where the police officer had power to compel compliance with the Section 44 procedure, had express powers to use reasonable force and or to detain a person who refused to submit, and for 30 minutes. Now, that's quite a different kettle of fish, isn't it, from just stopping someone to ask him to produce his identity card in circumstances where he's not obliged to produce it straight away. He can produce it at a police station later if he hasn't got it on him, and so on. So it's a question of degree.
It would be a matter of interpretation, and the legislature has not provided to produce same at police station, to produce same at any place, time, where the person requesting the card. And this element of coercion,
There isn't an element of coercion, is there?
That is, if we read paragraph 57, the police, that is when a police officer would stop the citizen. This element of coercion would be indicative, in my humble submission, of a deprivation of liberty. That is...
searching someone,
yes.
This was someone riding a bicycle and carrying a rucksack. Searching someone is a different thing from asking them to produce a card, which they don't even have to produce on the spot.
I cited this case in authority that even if the police officer stops someone for a short period of time, in the absence of any reasonable suspicion to passers-by near a protest, this would amount to an element of coercion, and by implication, this would amount, in my humble submission, to deprivation.
Well, we have the submission, and you've seen the way it might be put.
If I may conclude, my Lord, on this point,
right.
That is, a police officer would be exceptionally allowed to stop a person to either arrest somebody or ascertain his identity if that person is suspected of having committed a criminal offense. And for this authority, I would find support in the case of Brown versus Merkel, Wilcock versus Merkel at tab 69, the case of Brown versus Texas at tab 28, the case of Gillan versus Quinton at tab 32, and two local decisions, the one at tab 60, Sheriff, by late Justice Annie, and the case of Manraj versus ICAC at tab 42.
Right.
And I have already developed the argument in my statement of case. I would propose to move on, if I may.
Thank you. Where do we go next?
My Lord, before I move on, at tab 42, the decision in tab 42, volume 3. Though it is a one-judge decision, I would invite your Lordship's attention to pages 1745, 1746, the 1745, the second sentence. If there is no reasonability in the suspicion, the effect would be drastic for a democracy. One officer's mere submission can set the whole police force and state apparatus running and make a mockery of the citizens' freedoms and liberties.
Sorry, where are you reading from? I'm so sorry.
Foot of 1745. Last two lines.
1747, the bottom, and on the next page, 1746, where, my Lord, if it...
You were reading at the bottom of 1745, top of 1746.
One single officer's suspicion would make a difference between a dictator...
Well, this is a discussion of what reasonable
Yes.
ground to suspect is. How does it help us?
And that is to find support that exceptionally, when there is reasonable suspicion, the police can stop somebody, even to ascertain the identity.
Yeah. Right.
But how is that relevant to this case?
By virtue of Section 7, that is, it is a serious inroad. Any person can stop and be required to produce his identity. Besides, the identity card is a contactless smart card with RFID, akin to a tracking device, which the citizen has an obligation to carry at all times for random production. That is, the citizen will be carrying in his pocket, akin to an electronic bracelet, and all his rights to liberty, freedom of movement would
Are you
become
saying that this can be
odious.
detected in his pocket even without his being asked to do it?
By virtue of the law, he would be required to produce
Yes.
at random
But
request.
you're not suggesting that this would enable, for instance, satellite tracking of the movements of everybody?
If we can, my Lord,
I mean,
we cannot predict with certainty.
contactless cards operate at a range of a few feet at the most, or a few inches, in fact.
I understand with the installation of biometric cameras, which would come in the future, it would be possible to track the movement of citizens of Mauritius such that we will become a surveillance state rather than a democratic state.
Well, anything might happen in the future.
Was there expert evidence about this?
We have expert evidence that the card is a contactless smart card, can be read at a distance.
At what distance?
We have the version of the respondents that it can only be read at 10 centimeters. We don't know with advent of technology if it can be read at a longer distance. At the back of the card, there is an RFID, radio frequency identification, which I'm made to understand scientists would insert in animals so as to monitor movements in huge forests in the South American continent or on the African continent, so that at the end of the day, the citizen can be tracked down, his movement can be tracked from morning
Well,
till...
if the government starts to do that, then I can understand that you would have some cause for complaint, but there's nothing in the statute which authorises that. It would be, that I can see, would be a considerable infringement of privacy.
My Lord, unfortunately, as Lord Lane has put it, arbitrariness does not stand at the doorstep with a moustache and armband with a swastika. It creeps insidiously. And these are the first step by virtue of this card, RFID, contactless microchip containing the details of the citizen becomes vulnerable.
Well, I mean, you could say the same about mobile phones.
Yes,
Potentially, no doubt, they could be used to track every Mauritian citizen who keeps his mobile phone on wherever they go.
Yes.
My
Lord, this...
But this is all a risk that you would have to show was a real one, and I'm sure the Mauritian government will strongly deny it intends to operate a snooper state.
My Lord, it's true that with mobile phones and with laptops, we can, through Google, know the movement of...
But we aren't resolving all these problems, which could be myriad over the next 50 years.
But the difference...
We're looking at a very narrow point.
Yes, I'm sorry, my Lord. The fundamental difference, if I may, my Lord, is that there is consent. The person consents on having a mobile phone which can track him.
Yes, I see.
Or a laptop or an electronic device which enables him, without his consent, he can be tracked. And all constitutional rights...
People don't consent to having a mobile phone which can be used to track you. They do, when you have your mobile phone on, you do not consent to the government tracking your every move.
That is, you are aware you can put your mobile off if you don't want to be tracked by Google.
The mere fact that it would be possible for the government to do this doesn't mean to say that you have consented to its happening.
This question was put to my client, and my client said he had a very basic phone because he don't want his...
Well, your client obviously is sensitive to these things, but I think on this point,
yes,
if you're suggesting that the fact of having your mobile phone on is consent to the government tracking you wherever you are, I think you've got an uphill task to persuade, at any rate, me, that that's consent.
Yes. My Lord, the fundamental, that is, the main argument is without his consent.
Yes.
All the constitutional rights would start by except with one consent. If we have a look at Volume 1.
No, you can. I think you needn't worry about it. We accept that you can consent to most things which would otherwise represent your fundamental right. I think you were going to go on to, if I'm right, privacy in Article 8, or am I wrong?
If I may move to the next issue, my Lord, the issue of inhuman and degrading treatment.
Inhuman and degrading treatment, right. Sorry, I missed that.
And under inhuman and degrading treatment, I shall also be dealing with protection of the law. The constitutional provisions that are engaged for degrading treatment is sections 1 and 7 of the Constitution. My client is saying that the fact that he's being forced to give his fingerprints against his will amounts to a degrading treatment that is being inflicted upon him. The Supreme Court went on to define what is torture and cited the case of Virasomi versus Commissioner of Police, which is to be found at tab 68. Tab 68, the case of Virasomi versus Commissioner of Police. It is my
This is a Mauritian case, is it?
A Mauritian case of the Supreme Court of Mauritius in the 1970s, where the actual Prime Minister of Mauritius appeared. This case concerned the detention of political prisoners under the Labour regime. And the issue is not relevant here because we are not complaining of physical torture or mental torture.
So what's the principle you get from this?
that is the detention of political prisoners.
So all you're saying is that the Supreme Court shouldn't have referred to this case because it
Yes,
has nothing
yes,
to do with yours, so we don't need to look at it. Your
Right.
position is it's irrelevant.
Yeah.
Yes, my lord. Section 7 of the Constitution provides protection for, that is, no person shall be subjected to torture or inhuman or degrading punishment or other such
So
treatment.
what's the degrading treatment here?
What is degrading treatment, my lord? I have tried to find what is the
Yes,
meaning.
but what do you say is the treatment
Yes.
which amounts to degrading treatment on the
That
facts
is
of our case?
A person against his will is being compelled to give his fingerprints to obtain the ID card.
Why is that degrading?
Doesn't sound very degrading
This
to
is,
me.
that is, irrespective of his consent, the will of the state is being imposed on him.
Yes, but I mean, the will of the state is imposed on quite a number of people. One may find it unpleasant. I think most people who go to America feel a certain sense of reluctance.
Again, my lord,
But to say that it's degrading is a different matter.
the issue would be one of consent, my lord. That is, if
Well,
I,
we've got that. I mean, obviously, if you consent, there's no problem.
element of choice. If I want to go
Well, a bus
to
conductor
America,
might tell you to go and sit at the seat at the back when he wanted to sit at the seat at the front, but
it would be an issue of choice. Here, appellant has no choice by virtue of being a Mauritian citizen. He is compelled to give his fingerprints to obtain that card.
so anybody who's compelled to do anything by law is subject to degrading treatment, are they?
For someone who is innocent, has not committed any criminal
That's
offense.
your proposition, though.
Yes.
Involves saying
And-
that anybody. Your proposition involves saying
Yeah.
that anybody who is required to do something without their consent is being subjected to degrading treatment. That's your proposition, isn't it?
Yes, my lord. This would be
Well, we probably carried it a bit further. We will probably refine it a bit. You say something what to do with your physical
yes,
integrity.
personal data.
Yeah.
Yes.
So it's anyone who's compelled to give physical data, which would otherwise be personal to them, against their will.
Yes. My lord,
So if somebody takes a photograph of me without my consent, have I suffered degrading treatment?
my lord, here it is the taking of your fingerprints to extract the minutiae to be stored either on a database or on the chip of a card. which would
Suppose
be
that,
different.
suppose that the police take a photograph of people in the street.
My lord, if
Is
I
that,
may
is that,
come-
there may be a number of objections to that, but do you submit that it's degrading treatment?
My lord, if I may answer this question. But prior to that, the issue of going to America and the biometric passport. If I want to travel, I have the option to take.
Well, wait a minute, you don't. You're entitled to freedom of movement on your case, so that it's not an option, it's a right. So any restriction on it should be degrading on your case. I mean, on your case, surely applying for a passport is degrading experience because you have to submit to being photographed and having it.
Photograph would be different, my lord. But
Why?
Fingerprints occurred prior to the National Identity Card Act only in circumstances of, in a criminal context. If we have a look at the legislation of Mauritius, exceptionally, when a person was arrested upon reasonable suspicion, the police had a discretion to require that person to give his fingerprints. This is under section 221.
But your difficulty is surely that the true position under this constitution is that this situation is protected by Article 9,
Yes.
as indeed the court found.
Well, we'll come to it.
Pardon, my
We will come to
Come to it.
but if we're trying to
Privacy.
if we're trying to construe the constitution
Right. Yes.
as some sort of
interlink these rights, privacy.
it seems very, very bizarre if you've already got an express provision for this very kind of situation in paragraph 9 that we should be grappling with.
I suppose degrading treatment can affect your privacy, but
Well, it could be. I mean,
My lord, degrading treatment.
have you got any authority which
Yes.
comes anywhere near this.
We have the decision of the European Court of Human Rights in the case of Raninen.
Where's that?
That is at tab 56, volume 4. It concerned a situation where a person has been consistently refusing to perform military service. And in that jurisdiction, it was an offense, and he reoffended, so he committed a criminal offense. He was handcuffed. He put forward that he was treated in a degrading manner. But the court said it was not degrading treatment, but the court did define what is degrading treatment if we look at paragraphs 49 and 50, which would be
Yes.
What page?
it would be at paragraph
1982.
55.
Oh, I see. 183.
Page 1996. 1996, the second paragraph is relevant, which starts with
So which paragraph are we in? I thought-
second paragraph, page 1996.
Oh, I see.
1996.
Yes, not the Commission's opinion,
that's the
but the
Yeah.
Court's judgment.
Yes, I see.
Well, are you submitting that the object of
That is,
asking somebody for their identification is to humiliate and debase them?
the paragraph would read as follows. Furthermore, in considering whether a punishment or treatment is degrading within the meaning of Article 3, the court will have to regard whether its object is to humiliate and debase the person concerned, and whether, as far as the consequences concerned, it adversely affected his will or personality in a manner incompatible with
Well, asking for his fingerprints doesn't seem a very good description.
This was unnecessary handcuffing, which was humiliating in public, whereas asking for your fingerprints in private. Anyway, that's the authority you rely on.
We haven't got a better case than that.
if your lordships will bear with me,
Well, perhaps I ought also to look at paragraph 59, because the court found it wasn't degrading, even in the circumstances of Ranelagh.
Yeah,
There was no violation in that.
right.
Who told that?
Yes. You were indeed.
inhuman and degrading. At paragraph 55, it reads,
Yep, we've got that.
But you haven't got a better case on degrading treatments in your favour than this one. Is that right?
I don't,
You haven't got a better case than this, the best you can do.
I will come back to the definition of degrading treatment in Ranelagh. Right now, I don't have it under my hands.
Right, well, let's go on then.
Right. With regard to inhuman and degrading treatment, if a person, my client, fails to give fingerprints to obtain a card, the penalty that he is liable is up to 5 years imprisonment and 100,000 rupees fine. Under the criminal law context, under the Criminal Procedure Act, which is to be found at tab 23. It is volume 1. That is the obligation to give fingerprints arose, it is my submission, only in the criminal context prior to Identity Card Act.
Sorry, what is page 1409?
1409.
Criminal Procedure Act.
This is the Criminal Procedure Act 1853, which was dispatched to Mauritius by way of ordinance when Mauritius was a colony of the UK. And
Sorry, which page again?
page 1409.
Thank you.
It would be the first volume, my lord.
So what's that got to do with our case?
Yes. In a criminal context, my lord, even a person is suspected of having committed a criminal offense, the police may require him to give his fingerprints, whereas a person, the next subsection, section 222, if a person is convicted of a criminal offense, which can be any offense, rape, murder, etc., the magistrate or the court still has the discretion not to order that person to give his fingerprints. Now, if that convicted person who has been found guilty beyond reasonable doubt does not give his fingerprints, he would be committing a contempt of court, and the sentence is imprisonment for a term not exceeding 6 months. My argument, my lord, is a person who has been charged, convicted, proved beyond reasonable doubt guilty, disobey the order of the court, he is likely to get up to 6 months imprisonment for not submitting his fingerprints, whereas my client, who has no criminal charge, not subject matter of any criminal investigation, failure to give his fingerprints would render him liable to up to 5 years imprisonment, plus 100,000 rupees, almost.
Up to 100,000 rupees. It's all within those parameters for the criminal court, isn't it?
Yes, madam.
Very well.
So, this would infringe, in addition, my client's protection of the law. Why I say protection of the law, my lords? Because what the legislature is doing, the legislature is turning an innocuous omission, failure to give fingerprints to obtain a card, into a criminal offense carrying a high penalty. And upon being charged, prosecuted for such an offense, my client will have an unconditional burden of proving his innocence before the court.
Did you argue this point in front of the Court of Appeal?
Yes, my lord.
Is it dealt with in...
No, it's not the Court of Appeal, my lord. It was
Sorry, the Supreme Court.
Supreme Court
Did you-
first instance.
Is it dealt with in their judgment?
It has not been considered in the judgment, my lord, but during exchanges of my oral submission, I was invited to give more examples. That's why I cited the case of Velvindron versus the Queen.
Is it in your appellant's
Yes, my lord.
case? Can you just take... Where's the passage dealing with length of sentence?
It is in my appellate's case at paragraph 58, if I can look for the...
Paragraph 58 is about health details.
Yes. Now, I'm just looking at the bit relating to length of sentence.
It's 78. Paragraph 78 is the part of your case.
78.
Oh, yes.
Indeed, mine.
Right, so,
In paragraph 78, rather overstates the case in the fourth line.
yes. It's not less, no. It should be not exceeding.
But quite apart from that, I don't quite follow the point about the burden of establishing his innocence. Why is there any burden on him to establish his innocence?
That is the statute as couched, the law as couched. It would be a criminal offence not to give fingerprints, not to obtain that card.
The prosecution would have to prove the refusal.
Yeah.
He will have to come forward, and what is the defence? There is no defence.
Well, there is reasonable excuse is a defence. So that's the only point on which a suspect could be said to have an onus. I mean, if you were hospitalised as a result of an accident.
Which would not apply in my client's case.
But he wouldn't have to prove his innocence. The Crown would have to prove his guilt.
Yes.
Yes.
Anyway, that's the point about
My Lord,
sentence, yeah.
here anew the legislature has not provided for any proviso, any excuse for any defence.
Well, it has. It's provided for reasonable excuse.
If you have a reasonable excuse, you're not guilty.
Where's that?
Section 10A3 on page 1136. Any person who without reasonable excuse.
It's a transitional version.
I think,
That just covers the 10A1.
yes, I think that's just one.
So I mean, it's 9.2. Every person who contravenes this act shall commit an.
Oh, I see. So I see. That's a transition. Yes, sorry. Yes, you're quite right. That's a transitional version. Yeah. Yeah.
They'd have to prove the contravention.
My Lord, outside. Indeed, my
I
Lord.
do take your point that there's something rather unreal about the idea that somebody's going to be sent to prison for 5 years for failing to provide a fingerprint.
This sentence itself would be an inhuman and degrading treatment. Failure to obtain a card up to 5 years.
That would be a good reason for persuading the court not to impose such a sentence.
And it would not be proportional, my Lord.
But it's only the maximum. It's not in practice what's going to
And
happen.
the short answer is that the legislature has not considered the implication of the National ID Card Act. Otherwise, it would have provided for same in the Constitution, the empowering section, and then passed the enabling act. And I have relied, my Lord,
So, section 3 now of his submission.
It must be on to privacy now.
Privacy.
Yes, where do we go
Privacy.
now? Yes.
I have put in the case of Velvadron versus the Queen and Police versus Fra. Velvadron was...
Just give us the references.
Yes, my Lord. 67, my Lord.
67.
And 52. 67, we can have the judgment of late Justice Garrick and late Justice Maurice Roux. Late Justice Maurice Roux was a former pilot during the Second World War, and he brilliantly fought amongst the many against the Nazi invasion.
Sorry,
And
which
his
page you on?
judgment
Which page you on?
is to be found at page 2215. Whereby the second paragraph, the appellant was convicted and fined for having found in possession of wood without being able to account satisfactorily for such possession.
Yes.
So,
So the analogy, failure to obtain a card and they're prosecuted for possession of wood is considered a criminal offense. Here, failure to obtain a card and innocuous omission, in my humble submission.
Well, why is it innocuous? I mean, this is a serious scheme which presumably only works sensibly if everybody has a card. So that's no doubt why they've
Yes.
produced quite a surprisingly large maximum sentence.
And
but what help do we get out of this case?
What is the principle in
the,
this
the,
case?
the point which I would like to make is the legislature, just like in the case of Velvindron and Police versus Fra at tab 42,
Yes.
the legislature is criminalizing an innocuous act, and here the legislature is criminalizing an innocuous omission.
It's not an innocuous omission. If the scheme is to function,
Yes.
it has to be universal. So you either have to challenge the scheme as a whole, which you are doing, but if the scheme as a whole stands up, the penalisation of its infringement can't be complained about, can it? It can't be regarded as innocuous.
My lord, the answer would be that the scheme as a whole is being challenged, and the courts in Mauritius, they have the power to control constitutionality of legislations, acts of parliament, which they did in the case of Velvindron, which they did in the case of Police versus Fra,
Yes.
which they did in the case of Police versus Koirati versus State, and so many cases. That is, whenever an act of parliament would infringe some provisions.
Well, I don't think you need to tell us that. I mean, you wouldn't be here unless we recognise that we too are acting as a constitutional court. We're applying the Constitution, and if there's a law which is contrary to it, it is invalid pro tanto. But the question is whether there is anything wrong with this law, bearing in mind that the scheme needs to be a general scheme and some penalisation is appropriate.
On this issue, my lord, if I move on to the next issue, the right to privacy, as and when I develop this issue, the third issue, right to privacy, I shall be able to answer your lordship.
Right. Now you're in an area where the Supreme Court thought that you had a basis for your arguments.
We could have restricted our case on the right to privacy, but we think that these rights are interconnected: liberty.
Yes, right. Well,
Freedom of
let's
movement.
focus on right to privacy.
Right to privacy, we're complaining that sections 1, section 3C, section 9 of the Constitution, coupled with Article 22 of the Civil Code, is being infringed by the National Identity Card Scheme. If we have a look at the Constitution, which is at tab,
Right.
Well, you won on the 9-1 point, didn't you?
at tab 21,
Do you want to go further than rely on section 9.1?
9.1 plus 3C as well.
Well, section 3C, this raises a question which is quite a common question in relation to Westminster-style constitutions, namely whether the introductory section, which is section 3, is self-standing source of constitutional rights, or whether on its true construction, it is simply an introductory section introducing the fundamental rights
Yes,
which are provided for by the later sections. And of course, it all depends on the wording of Section 3 or its equivalent.
yes, my lord.
But if you're going to argue this point that Section 3C is an independent source of rights, a general right of privacy, you would need to look at cases which are not in your bundle, such as Maycock and the Commissioner of Police of the Bahamas,
Yes, my
which it discusses a number of constitutions, including the Bahamian constitutions, and puts them into two categories. And I think when you look at it, if you look at it, you will find that this is in the category of introductory section rather than independent source of rights. But it may be this difficult for you to address at this stage, but I don't think you've got any of the authorities in the bundle, have you?
Your best authority on this is tab 62, volume 4, which is
United Docs.
exactly, which is a judgment of the board, and you rely on page 2149, first full paragraph. Their lordships have no doubt that all provisions of chapter 2, including section 8, must be construed in the light of the provisions of section 3. The wording of section 3 is only consistent with an enacting section. It's not a mere preamble or introduction.
Well,
That's your point, isn't it?
Yes, ma'am.
Very well.
That's very helpful. That takes a rather different view from the one I was putting to you.
We have the decision of the board in Société United Docs. The Société United Docs, the Supreme Court decision as well. That is, it is both at...
But even if it's freestanding, as it
Yes.
were, and deserves independent consideration, what does it add to section 9?
What it adds, sometimes the Supreme Court interpreted the Constitution going back in the past, that is, rights which have existed prior to the Constitution. And on some occasions, the court went back as far back to say that the Déclaration Droits de l'Homme du Citoyen, when Mauritius was a French colony, would have the impact of law, that is going back in history. But for the purpose of this appeal, I do not propose to go back in history. On this issue, we have the case of Pierre Bocuse, the dissenting judgment of Justice Annie. We have as well the decision of the, I would beg leave to put in a copy. We have, yes.
Are you presently submitting that there is an infringement?
Whether,
Are you at the moment submitting that there is an infringement of the right of privacy? Because if you're is that your submission, the one you're making now?
yes. The answer, my lord, would be that Section 3 as well would protect
But
privacy.
you have won on that point,
Yes,
and it's not being suggested against you by Mr. Guthrie
yes,
that you shouldn't have done. The issue is not whether there is a prima facie infringement of the right of privacy, but whether it's justified.
yes, my lord. Yes. No, my lord, on this issue, I'm sorry, my lord, the Supreme Court does not recognize that there is a right to privacy in Mauritius.
No, they didn't pick up the point which Lord Wilson has
They say that
highlighted, namely that Section 3 has been held, I think they didn't pick that, did they? That it's been held to be an independent source of rights.
I think they said, didn't
They said
they?
that.
What did they say?
Mr. Tiluk Tehari, I think they said, well, now, come on, let's read section 3C. This is privacy of home and other property.
Yes.
That's difficult for the claimant, but easier for the claimant is section 9.1, which is talking about people not being subjected to the search of his person or his property. So that's where you scored some sort of success, Mr. Tilak Tehari, because this was generously, as the Supreme Court thought, construed in favour of being tantamount to, or within the broad meaning of, a search of the person. So you had more success with Section 9 than you did with Section 3. And you had success in particular in relation, as I understand it, to the retention and storage of this data.
Yes.
Where you failed to succeed, even under Section 9, was in relation to the taking and recording. Am I right?
Yes, Madam.
So your job is to persuade us, it seems to me, within Section 9,
Yes.
that even the taking and recording of the fingerprints is a constitutional violation, and in particular, that the final words of Section 9(2), which provide that it be shown, and apparently that it be shown by you, although you're disputing this, that the provision is not reasonably justifiable in a democratic society. It does seem that, from the words "is shown," that the onus was on you, as the Supreme Court said, to show that this wasn't reasonably justifiable in a democratic society. The Supreme Court held that you'd not shown it not to be reasonably justifiable, and so, in the end, you failed in respect of taking and recording. Am I more or less right?
Yes, Madam.
Very well.
But I would beg to differ with the reasoning of the Supreme Court. The Supreme Court cited a number of cases to say that constitutional provisions should be interpreted generously and purposively. But then, when it came to the right to privacy, the Supreme Court of Mauritius adopted a very restrictive approach. The Supreme Court of Mauritius said, if we look at the record, that there is no right to privacy under the Constitution.
Well, yes, but and where do you get it beyond the provisions of Section 3 and Section 9?
Yes.
You mentioned Section 1, but we can hardly get it out of that, can we?
Yes. But what the court said
Page?
the court said that Section 9
Yes,
would,
but where did they say that?
yes, Madam.
Well, I think is
The
it.
judgment at page 845, my lord.
4-5, thank you.
Well, but didn't they say? I think that's the beginning of it. 862, maybe. The last two paragraphs.
It would be at page 18 of the judgment, which would be page...
Yes, that's 862. But it starts on 861, actually.
It would say that provisions of Section 3 and 9 of our Constitution are not the equivalent
Yeah.
and would
Of
not,
Article
as a result, constitutionally protected rights of privacy and private life in the same manner and to the same extent as Article 8 of the European Convention. It is my humble submission, my lord, that despite that the court cited a number of cases to say that the Constitution should be interpreted broadly and generously. And here I am referring to the judgment of the Supreme Court.
Well, I think we can accept that.
I mean, then they construed Section 9 right, on page 866. And they held that there was, on the face of it, an infringement of Article 9(1).
Why do you need a broader right of privacy than it's because of the point about initial? Perhaps you would just define it. It's a point about which aspect again is it? I think right to search would cover the initial taking, wouldn't it?
If I may, Madhewoo.
Yes.
The
Right
Supreme
not to
Court
be searched.
cited the cases of Olivier versus Boutiquier, Antoine, Attorney General versus Mamadou Jobe, Minister of Home Affairs versus
And
Fisher.
their authority for what proposition?
These authorities, they hammer one point that the Constitution must be interpreted in such a manner that the letters should be construed to give full effect to the spirit of the
But
Constitution.
they did that. I mean, so far as Article 9(1) is concerned,
Yes.
since you succeeded on the basis of it, they must have...
But
I don't see what you can complain about.
I must say, I agree with, at the moment, I agree with Lord Clark.
Yes.
You want a generous interpretation of Section 9(1). You got it. You got a holding, bottom of 867, that there was an interference.
Yes.
So then, as it were, the Supreme Court turns the page and looks at Section 9(2),
Yes.
which is perhaps what we should be doing soon.
That's fine. But prior to coming to that, the court made reference to broad, generous interpretation.
Yes, but what further protection do you need? Lord Wilson's just referred to the interpretation which said that the compulsory taking and recording of fingerprints of a citizen of Mauritius discloses an interference with the plaintiff's right guaranteed by Section 9(1).
Yes.
Now, what further,
Yes.
what further aspect of this statute do you want to say deserves protection and should not be interfered with
Yes.
because of the right of privacy?
That is-
Why was this too narrow? What more is there?
Privacy. That is, it has restricted the approach that it is limited to the right to search. That is Section 9(1).
Well, that's your.
And
But why is that an insufficient peg for you? Why does the peg matter?
because it extends, it goes beyond the right to search. What type of right does the citizen has over his private data?
But you won on that point because they said that...
Is it not a right to privacy? Is it a proprietary right? So this is the whole
It's
issue.
a proprietary right.
The
Privacy.
fact is you won on Article 9(1). There's only one remaining question.
Yes.
That is, what is the position under Article 9(2)?
They
What
treated the article, the
we would say
right of
that-
search, as extending
Yes.
to exactly what you're complaining about.
It would go beyond search because it is
No,
not
but
only
why does it matter? I mean, as a matter of intellectual interest,
Yes.
it would be intellectually interesting to see whether this constitution contains a right of privacy which is not tied to the concept of search. But the concept of search has been treated very widely. So why does it matter whether it should have been analysed slightly differently? Is this a pure academic point or is it practical?
Yes, on the practical point of view, my lord, if I may. That is, notwithstanding that there is obligation to give fingerprints to the state, this data, these biometric data will be stored on a contactless smart card. And prior to that, it will be stored for processing purpose on a database. And this information will be very vulnerable by virtue of the Data Protection Act, so that the citizen has no control over his private data, how his private data can be transmitted to various parties, to foreign governments.
Well, these are
Without-
these are consequences, but that is not answering the point that the court is putting to you.
Yes.
The Supreme Court in Mauritius has held that in effect, that the coercive taking of fingerprints is an interference
Yes.
under 9(1). And that is a reference to Section 4 of the Act, where every person is required to apply for an identity card, and every person who applies for an identity card will allow his fingerprints and other biometric information to be taken and recorded. So at the very outset of this exercise, you are being told there is an interference with your constitutional rights.
Yes.
And indeed, the whole of paragraph of page 866 makes all your points for you, as far as I can see. I mean, they say at the end that we must remember that it's not an act of Parliament. We must look at it as a charter or a covenant which must be given a generous and purposive interpretation. So they've got all your points. They've decided in your favour. Seems rather churlish to complain about that.
Well, tell us, since you are concerned to make the point, tell us in one sentence which section of the Constitution actually suggests any different approach to the one which the Supreme Court took. In other words, is there any basis for your alternative approach in the Constitution? Which section is it?
I know. If we take Section 1, Section 3C, and Section 9 together,
Right. Well,
we can reach the conclusion that they are similar to Article 8 of the European Convention, and that the right to privacy is guaranteed under the Constitution of Mauritius.
Subject to 9.2.
And besides the obligation of giving fingerprints, what is the outcome of the data that has been collected, and how the citizen can, what is the complaint of the citizen is that his right to privacy will be infringed in view that this card is a contactless smart card, and prior to that, his data is on a database.
all right. Well, I think we've got the submission.
Yes.
You say it arises by reading not just sections 3 and 9, but also section 1. It's general democratic principles, and we look at the European Convention, and we should really read it in here.
Yes. Your Lordship made the point in the case of Koirati about section 1. What is the structure of a democratic state? And along the same line, my Lord, that is...
But Koirati was a pretty different case, because
Yes.
Koirati was about the fundamental question of separation of powers and
That
whether
is.
the executive could in effect arrest people
Yes.
by charging them with criminal offences and in circumstances where they couldn't get bail. So, I mean, I think we've got the point.
Yes.
Shall we move on?
My Lord, but, on the issue of, that is, the right to search, though the court cited these authorities, it adopted the approach of the Canadian courts in the case of Feeney, an authority which I have missed, we have missed during the binding exercise, and which we propose to put in at this stage, my Lord. The case of Feeney, a Canadian case on which the Supreme Court has placed reliance, and reference is also made in the respondent's statement of case. The case of Feeney was a situation where a person was arrested in respect to a charge of murder. His T-shirt bore stains of blood, and in the course of that exercise, the police did not allow him access to his counsel, and through a search, which was described as an unlawful search, they came on his premises and they arrested him. Fini.
This is the case which is discussed in some detail by the court in our case, at page 867, 868.
Sure. So in the case of Feeney, the fingerprints was taken in a context of criminal context. That is, a person is under investigation, which is different from the present case, but even in Feeney, the majority judgment is fini. No? What is relevant is at page 17, the paragraph on fingerprinting was as an incident to a lawful arrest. The court has this to say: fingerprinting as an incident to a lawful arrest has been held not to violate the Charter. Here, however, the arrest was unlawful and involved a variety of Charter breaches.
But the Supreme Court were aware of all that. I mean,
That is, the court recognized that the position is under the Canadian Charter is very restrictive, and this is to be found at.
well, the Supreme Court recognised that on page 866. They set out the Supreme Court of Canada held that compelling the accused to provide fingerprints in the present context was a violation of Section 8 of the Charter, involving as it did a search and seizure related to the appellant's body, about which, at least in the absence of unlawful arrest, there's a high expectation of privacy. Then they say, we note that Section 9 of our Constitution is couched in wider terms than Section 8. So they have all your points. They've taken them into account in your favour.
But even though they said, they failed to come to the conclusion that it is similar to Article 8 of the European Convention on Human Rights.
What in the Feeney case supports the proposition that it is similar to Article 8? What is it you want us to look at in this case?
The point that I want to make, my lord, is that fingerprinting is taken only in criminal context, and even
Well, that slightly begs the question. I mean, this scheme demonstrates that that's not necessarily so. It may be familiar in a criminal context, but it doesn't mean, say, it's only legitimate in that context. Anyway, my Lord's question was, is there any help in Feeney or any other case for your submission that we read the European Convention rights into this Constitution in this respect?
My submission would be that the right is not a right limited to the search of the person, but would involve private life, that is, privacy, and that the data of the person also is an issue.
Right.
And it has to be interpreted generously. In the case of Murray, the European Court of Human Rights interpreted Article 6 generously to include the right to be informed of access to counsel into the provisions of fair trial. And in India, the courts in India construed Article 21 of the Indian Constitution, though no express mention has been made of privacy, as including the right to privacy. And therefore, on this score, the Supreme Court has failed to see that the provisions under Section 9(3) would be similar to that afforded under Article 8 of the Convention. And that, apart from the obligation of giving fingerprints, the data that is stored on the card also will be an issue. And the rationale, the court would later conclude that storage and retention would be unconstitutional. That is, storage and retention would infringe Article 9 of the Constitution. The same rationale would apply to the data that is stored on the contactless smart card, that is the microchip of the contactless smart card. And in addition to that, my lord, we have the view of the Conseil constitutionnel of France, where the control of legislation is before an act of parliament is assented to, becomes law. In Mauritius, this control of constitutionality comes afterwards, but the courts in France came to the same conclusion that those data cannot be stored on a database. On this, we won. But also the obligation, that is, in France, it is optional for the individual to give his fingerprints. His fingerprints are not stored on the identity card. The identity card is optional. In India, the mandatory obligation has been challenged. Justice Puttaswamy of Karnataka High Court obtained an injunction, notwithstanding that the Indian Constitution does not provide expressly for right to privacy. This is the position in India. In the UK, the same type of card was introduced by virtue of the Identity Card Act 2006. The difference between the card in the UK and the Mauritian card is the Mauritian card is contactless, can be read from a distance. The respondents would say it can be read at a distance of 10 centimeters. But even though the data of the individual is very vulnerable, there is expert evidence it can be downloaded, accessed to at a distance. Therefore, the person is very vulnerable to identity theft. This card can be cloned. His email accounts, his bank accounts, everything will become vulnerable. And there are no safeguards that have been provided by the legislature regarding the national identity card. For instance, persons taking the data, they have no obligation of confidentiality. And by virtue of the Data Protection Act, this data becomes extremely vulnerable. And the argument that
But is there an obligation to put your banking details on this?
Yes, my lord.
An obligation?
No. Banking details, we do not know. But what we know is...
No, there's no obligation to put your banking details on this card compulsorily. You may say that in the future, in some much worse world, that may happen. But that's not the world we're judging. There's a very limited amount of material put on this card, isn't there?
The legislature has provided for all the information as may be prescribed.
Yes, well, that's the same point we had at the very beginning, isn't it? That as and when the legislator goes further, if it oversteps the mark, you will have a complaint at that stage.
But we have...
But you can't assume the worst. You can't assume that they're going to behave intolerably or wrongly in the future.
But in any event, other information as may be prescribed. That is what they wish to put on the identity card. Your complaint is what the person seeking an identity card is required to do. And what he's required to do, as well as produce his birth certificate and certain documents, is allow his fingerprints and other biometric information about himself to be taken and recorded. And biometric information means data about his external characteristics. So there is no requirement in the offending section 4 for the provision of information of the sort that you talk about.
Section 5, my lord, of the NIC Act.
Yes.
At page 1133.
Yes,
Volume 1.
I have it in front of me.
That is, what is to be contained on the national identity card. And on the next page, 1134, we have a name, surname, and it goes on date of birth.
I know. I've seen 5.2h, but I'm reading it in context of section 4.2.
So this is an application under section 17 of the Constitution, where it is provided for that where a person alleges that any of sections 3 to 16 has been or is likely to be contravened. That is, the appellant's view is these sections are likely to be contravened in the future. That's why he lodged a section 17 application. And our reading
When you say the sections are likely, you mean that H is likely to be in some way misused to include information which the government might have itself from tax returns, for example,
yes, madam.
which would be undesirable. Well, you'll be able to complain at that stage. We mustn't assume the worst, must we?
My lord, we have to assume the worst because we are an island state, Republic of Mauritius, where in relation to liberty, please have...
I mean, where it says as may be prescribed, that means what? As may be prescribed in some document produced by the government.
It also means as may be constitutionally prescribed.
What we read from such other information as may be prescribed.
Well, under section 10.1, namely, the minister may make regulations, presumably. Isn't it?
So what are these?
Let's just get this entirely clear. Have there been regulations, Mr. Tiluk-Harry,
Yes, ma'am.
under Section 10 in which other information has been prescribed
Yes, madam.
to be borne in every identity card?
We have regulations that have been made.
I know, but have regulations been made which prescribe other information to be included in an identity card? So I haven't read of any or found any.
Yes, madam.
Let's get it clear.
Yeah. My lord, we have...
What's the answer?
That this regulation was made after a challenge was lodged before the Supreme Court, an injunction case, whereby appellant was unsuccessful, and we raised this issue that this law is not complete. A regulation was voted retrospectively in October to have effect as from September. And
So where
this
is it? Where is it?
GN 216 of 2013,
Have we got
where
copies?
it has provided for information.
Now, have we got copies in the bundle?
Yes, my lord. I understand the respondents will be putting in.
Yes, we have copied the regulations. It's necessary to understand that after the judgment, the originally proposed regulations were repealed and substituted with different regulations. But I can
Which are
explain.
these?
These are all of the regulations which are relevant, so you can see the process.
Right.
And will we there find a prescription of other information to be included in the identity?
In the regulations, particulars in register regulations 2013, a number of particulars were specified. It's under divider 2 of the new bundle, and that said the following particulars: date of birth, photograph, signature or thumbprint, NIC number, residential address, fingerprints, and encoded minutiae fingerprints. But that, following the decision of the Supreme Court, was repealed and replaced by those at...
Sorry, these are new ones, are they, that we're looking at now, or are these the old ones?
No, those are the ones, I just read out the ones which were repealed
Sorry, yeah.
as a result of the judgment.
Yeah.
And then the National Identity Card Civil Identity Register regulations were substituted.
Tab 4.
That's at tab 4, and you'll see following information be recorded in the Civil Identity Register: entry in birth certificate, date of birth, marital status, entry in marriage certificate, official document, etc. And then there are the final regulations.
Seem to be rather more in 4.
Which at regulation 8 says that every identity card shall be
That's the current ones or the old ones?
the current ones,
Which are where?
which are tab 1.
I think tab 1 has the current ones?
Yes.
Yes, tab 1 has the current ones. And
1 is the current one. Not 4.
4 was the one which was repealed. I'm sorry, 4 doesn't deal with this. I'm sorry, these have only been obtained fairly recently.
4 is not on the card, is that right? 4 is...
Yes, 4 is in relation to the register. I'm sorry, 1 is the current one, and you'll see under 8, every identity card issued shall, in addition to the information specified in Section 5.2 of the Act, contain a barcode, a card control number, and a document security object. So,
What's a document security object?
what's that?
Document has been written here.
It's defined at the beginning, the hash value of the data of an applicant for an identity card, which is electronically signed by the MNIS certification authority system.
So
I'm not sure that helps me.
Are these additional things basically electronic methods of retrieving the original information?
That's correct. Yes, I understand that's correct, yeah.
It's not new information.
No, it's not new information. In fact, there was a certain amount of evidence, which obviously I can come to in due course, to the effect that there was nothing and no intention and indeed no capability of storing a lot of personal information on these cards at all. There was very limited storage space on them in the first place.
But it's accepted on all sides, is it, that the expression as may be prescribed in the
Yes.
in paragraph 5 contemplates the prescription being in some future regulation.
Yes. Yeah. That's right, isn't it? Yes.
Yeah. So the answer is that there really hasn't been any future regulation except for 1, which adds barcode, card control number, and document security object. It doesn't add anything else.
Those don't appear to be additions of information so much as additional methods of retrieving the existing information.
Yeah, quite.
Yes. Yeah.
Right.
My lords, this is an instance where the legislature has been coming piecemeal. We have regulations that...
That happens in all regulations. People are always, all governments produce
but
regulations.
These regulations were made with retrospective effect following what were the following exchanges in an injunction case, what were highlighted to the state, what are the loopholes in the legislation. And further on, if we look at the chronology at which these regulations have been made, they are trying to cure the defects that have been
That's
highlighted.
the obvious thing to do with the defects is to cure it.
Yes, trying, but it is a defect.
Lords, I don't mean to interrupt, but I think Miss Domer has very helpfully identified for me what is on the cards. And it's Section 5 of the Act, which you have under divider.
No, I thought we were looking at that.
Yes,
Yeah.
and it is that information.
Yeah,
But where we come to H,
Yeah.
that takes you only to Regulation 8 of the National Identity Card Regulations 2013, which is the first of the documents.
that's
that
what I
found.
thought.
So
Right.
I think that's a short, better answer than I was able to give the first time.
I think we got that. Right. Okay.
Yes, one. Coming to the provision as other information, such other information as may be prescribed. What we have to understand from this section is by way of an exercise to look at what was the intention of the legislature. And same is to be found in the Hansards. That is, the purpose of this ID card will be a multi-purpose card. It will contain...
Well, all that might be right.
Yes.
But when and if they produce some such regulations, then you will have an opportunity to challenge them.
But indeed, Madam, this application is based on provisions which are being infringed or which are likely to be infringed by virtue of Section 17(1) of the Constitution.
How can you suggest that it is likely that future regulations will be unconstitutional?
Yes.
That's your submission, as I understand it. I mean, it is possible that they may be. What on earth is the basis on which you submit that it's likely that they'll be unconstitutional?
This is because when we look at the intention of the legislature, just as the board has done in the case of Koirati, in the case of...
No, Colorado was about actual legislation.
Yes.
Right. Well, I mean, is there one passage in Hansard which says that we're going to introduce something which you submit would be unconstitutional? What's your best passage in Hansard?
Yes. It's on the Hansard.
Well,
We have the speech of the Prime Minister that has been. We have the speech of the then representative of
Yes,
respondent
which page are we on?
at tab 11 and 12.
Page?
Sorry, which page are we on?
Reference is made to a multi-purpose card at page 1265. The second paragraph.
Yes, well, this isn't going to show that anything unconstitutional is going to happen.
The Hansards of 2013 at tab 9.
Tab 9, yes. Page?
At page 1235.
Yep.
1235, it would be the
Page?
Was there a change of
MNIS
Was there a change of government during this period?
Yes,
Was.
there has been change in government.
The leader of the opposition is now the Prime Minister, isn't it?
That is-
Monsieur.
Most lawyers who were against the ID card, including myself, we form part of the new legislature. The council who appeared for Honorable Praveen Jagannath, and including himself, they are senior minister in the new government. And the situation has changed, but we are awaiting the decision of the board in this matter by the legislature as well as the people of Mauritius.
Sorry, whereabouts on 1235 or 1236 was it?
The former Prime Minister made reference, the paragraph starts with, MNIS project is a key component of e-government strategy. And it goes on to say a number of e-government services, like, for example, the e-health will be...
Is this a reference to the identity
Yes,
cards?
e-health.
Yeah, but this isn't a reference to the identity cards, is it? It's a reference to the project for setting up
Yes.
electronic resources for dealing with government information generally.
Yes.
Is it not?
And the card will be... Yes, my lord, if I may answer this question, is the project would include the database and the card as well. How could the citizen
How do we know
access
that? How do we know that?
The MINIS project is not. That's a much bigger project than just the card, isn't it?
Yes, and
Well, my lord is right, isn't he? But if he's wrong, please tell us. I mean, if you look at 1232, penultimate sentence, the relevant sections of the National Identity Card Act, as amended, will be proclaimed in the context of the implementation of the MINIS project. And similarly, 1234, the third paragraph, it has not been proclaimed pending the implementation of the MINIS project. So the MINIS project is some vast electronic data project which the government...
And also, if you see at 12:35, it says that a launch event for the new card will be held, I believe, in August 2013. That's the new card, including the Minutes project, and that's
Yes, ma'am.
3 years ago.
Mr. T. MNIS, it stands, does it not, for Mauritius National Identity Scheme.
Yes, ma'am.
That's the scheme we're looking at
This
at
is
the
the
moment.
scheme, yes.
Very well.
That is the database, including the card and how the...
Including the card, but not limited to the card.
Not
that right?
limited to the card. It would include the database as well.
But you're not
Storage.
complaining about the database is much wider. It has on it information, no doubt, about taxation, about health. It's simply a government database. The national identity card has on it very limited information. And that's the point being put here.
I understand the database for the purpose of identity card was a big project in Mauritius, alike in the UK. And the cost was 1.1 billion rupees.
No, but is what I suggested correct, that the MINIS project, the National Identity Scheme, has a whole range of government data which government has about individuals, including health, no doubt, but not necessarily information which appears on the card.
What they wanted to create, that everything becomes that is e-project. That is, through the card, one can have access to government facilities, and one goes to hospital. The e-card will reveal the details about the patient, including the health details.
Well, the identity card won't do that. The identity card, when inserted into the system,
Yes.
will release a lot of other information
Yes.
which is not on the identity card itself. It's simply a rapid way of identifying the person about whom you are seeking some information that is not on the card, but is in the broader government database. I mean, that's right, isn't it?
Yes.
Is that right or not?
My Lord, this would be, that is, the answer would be, my Lord, that this card is intended to be a health card, and the respondent made reference, gave interviews to the press to say that health data such as blood group, everything would be included in this card.
Mr. T. You cross-examined Mr. Ramar at length.
Yes, ma'am.
And we've got the transcript, we've read it.
Yes, ma'am.
You pressed Mr. Ramar,
Yes, ma'am.
who's the project director, I think, for the government of the scheme, and you said, what about health information? And he was quite firm that there would be no health information, probably no capacity to collect health information, but certainly no intention that any health information like DNA or blood types or anything like that would be on the card.
Yes, ma'am.
And Mr. Ramar's evidence has, so far as I can see, been accepted by the Supreme Court. So you can't start saying that there'll be a whole lot of health data in the card.
My Lord, the questions were put to Mr. Rao Rama about the project and what about the intention of the legislature, and he could not answer anything about what was said by the legislature, the purpose of this
Not surprisingly, but is my Lord right that the answers he gave were quite firm?
The answer was given, this aspect I'm dealing on when I will deal with denial of fair hearing, the hostile attitude of the court when plaintiff appellate was being examined in chief, and when respondents' representative were being cross-examined, how the court intervened. In the first place, representative of the appellate wanted to challenge whether Mr. Rama can represent the state or the respondent. He is neither a representative of the Attorney General or a person from an authorized government department.
So could
But I'm
you answer
afraid to
Lord
say that
Mance's question?
Yes, ma'am.
Did Mr. Ramar say to you, there is no health data
For the
going
time being.
onto the card?
For the time being, there is no health data.
Very well.
But what has been prescribe what is the intention of the legislature is to make it. And there is also the statement of respondent number 2, the minister to the press, which press cutting has been made part of the agreed statement of facts and issues before the Supreme Court, where he said in so many words that it is going to contain health details of the person.
You say that's in the statement of facts and issues.
Yes.
Can we just identify that then?
In my statement of case, it would be
No,
at
statement.
page.
Sorry, did you say?
Where is it in the statement of facts and issues?
Did you say statement of facts and issues? I thought.
Yes.
Sorry.
Page 1055, my lord, of the record,
10.
paragraph 56. We have elaborated on this issue. And
Your.
Hang on.
1055 of the record.
This is your case, eh?
Paragraph.
What's the paragraph in your printed case?
Paragraph 57, I think, is it? Hansard. It says the Hansard.
Paragraph 56, my lord.
So you've referred us to one of those. That's the reference we were looking at a moment ago, I think, e-health, and we've suggested that was related to the MINIS thing. So that's tab 9, and then tab 8 is the other budget speech you've referred to there, which we can look at, which is 2007 to 8. Is it?
Could you just give me the reference to the 2013 statute?
2013.
Yeah,
Yes, 21, isn't it?
21, is it?
Is it?
So now, where is
no,
this?
sorry, that's
Where is this press
24,
statement
24.
that you're referring to? I mean, I've got your case open. Which paragraph should I be looking at?
Tab 5.
What?
The statute is at tab. At tab. So we are talking about the National Identity Card Act and Section 5H at page 1134. Such other information as may be prescribed. Reference to page.
Well, all he says is, in 2007 to 8, in the budget speech, he said, other possible uses
Yes.
include health card. But it doesn't mean to say it's going to have any health details. It could just be a statement like we carry around in our pockets at the moment, namely that we're eligible to free health care throughout the European Union. It doesn't have any details of my medical conditions, if any.
In practical situation, that is, can we, in view that it is a contactless smart card, a person calling candidates for interview, will he be in a position to know who is diabetic, who is cardiac?
Well, we can obviously speculate endlessly about all that. Yes. Can I just sure I've got this right? The only further statute
Yes.
that we are concerned with is the one at tab which is post the debates we were looking at tab 24. There's no further statute apart from that.
Only tab 24.
And so apart from that, the only other legislative activity has been the regulations that we were looking at a few minutes ago. So I think it's time, speaking entirely for myself, I think it's time we got on to 9.2.
Yes, 9.2.
Which was a point upon which you lost. We've had a lot of time on the point at which you won.
The
What do you
court
say about-
said that we had a burden to establish that it is not reasonably justifiable in a democratic society.
Notwithstanding the text.
Yeah. I mean, if you look, I'm sorry to,
No, no, go.
let's not delay. I was just looking at the recent statement which you rely on, and all the minister is saying is it might have some other uses, such as pension card, bus pass, driving licence, or, he says, même plus tard de la carte de identité. In other words, he says, or perhaps later, it's page 213, health card. And so reading those together, and it's quite plain, it's not going to have actual details about your health. It's going to have indication that you're entitled to access these services, a pension, a bus pass, a driving licence, and so on.
This information is gathered from the interview of respondent number 2,
Yes.
which he gave to the press, which is contained in the press cuttings.
Yes. I see. It does.
It is to be found in volume 1, and the press cuttings would be found at page.
Is maybe you get something more under the heading of e-health, actually, a bit lower down if one looks at page 213, which might support.
200 to 204 of the record. At page 203, reference is made to the interview of the respondent
Yes.
as Annex D on the 10th of October 2013.
Yes. It's
And the interview will be found at pages 212
yeah.
up to
I think the interesting one is the penultimate paragraph on 213, which does seem to deal with this, as you were suggesting, a suggestion that you might insert medical information.
It's in French, my lord, and mention is made about e-health in the last paragraph from the bottom. That is second paragraph from the bottom. And reference has also been made to blood group. And
medical
I
condition.
cannot see the exact reference. I think it would be on the.
Well, there's the reference in the penultimate paragraph in 213.
Yes, exactly.
That when the patient can't tell what is his blood group or what condition he's suffering from.
Yes,
so that seems to suggest that this gentleman was envisaging
My lord,
the
it
inclusion
would be
of health
conversant with
information.
French, my lord. And souvent,
Well, it's a little.
It's not quite clear.
It's rather obscure. I mean, it seems to me to be equally consistent with the notion that the government will maintain a health database separately, and that to identify the relevant file concerning the individual, the identity card may be useful for that purpose.
Yeah, that's what I.
But in either case, nothing has happened yet.
So the details would be the health details, medical conditions from one.
And all this is speculation for the future, isn't it?
If it happens, you'll be able to raise your complaints if they are well founded on the Constitution, I think is the point we're putting to you.
My lord, it is our complaint, and it is by virtue of Section 17, subsection 1, in view that the respondent himself at that time gave.
Yeah, I think we're going over the same territory. We understand your point, and we now see that there have been some recent statements which may be slightly ambiguous as to what is contemplated, but even reading them in your favour, the point is that you can challenge it when it happens. I'm a little concerned. You've got quarter of an hour before the midday adjournment, and you've got half an hour afterwards.
I think it's an
I think that's right. Am I
It's
being?
an hour afterwards.
It's an hour afterwards. You're quite right. So, but I think we ought to move on.
I don't only. I have only one issue to develop, and I will be able to complete that in the next half hour after lunch, if
Fine.
this would be convenient to the board.
Yes. Well, carry on then.
Okay. And it will be my respectful submission that is the rationale for saying that the storage and retention of private data of the appellant would infringe his constitutional rights under Section 9. The card itself and the storage on the microchip as well, the same rationale should be applied, and this as well should be considered as infringing Section 9, subsection 1 of the Constitution. And if we look at the conclusion of the Supreme Court, my lords, same is to be found on the record at page 854. And the conclusion would be at page 879. Où est le jugement? But prior to that, my lord,
Which were the? I'm sure you've answered this question already, but which were the parts which you wanted, as it were, included in the Section 9(1) point, upon which you lost?
yes, ma'am. That is the taking and recording of fingerprints. We would say that the court said it is for the purpose of identification. It answers a pressing social need, and that we have failed to discharge the burden that it is not reasonably justifiable in a democratic society.
But the taking and recording of the fingerprints was, on the face of it, an infringement of Article 9(1),
Yes.
was it?
Yes.
But was there any part of your case on Article 9(1)
Yes.
upon which you lost?
So whether it passes the test of public order.
Yes, but that's 9.2.
That's 9(2).
9(2).
I'm just trying to discover whether there's any part of the debate on Article 9(1) upon which you lost and which you're now challenging. If the answer is no, please say so. But I got the impression that there was some area which you'd lost on 9(1).
I think you would like you would have liked privacy to cover expressly data storage and retention. Because at the moment, search, they spoke in terms of taking and that initial stage. But on the other hand, they did go on to say that the conditions for retention and storage were not reasonably sufficient. So they did treat
Yes.
Section 9 as embracing within the concept of search not just the mere taking, but also the retention and storage.
That part is accepted
Yes.
by the respondents. They're
Yeah.
going to legislate to deal with that.
My submission would be,
So you've got no complaint, apart from the general points you've been making, you've got no complaint about their conclusion on 9.1, and we're now focusing on 9.2. Is that right?
9.2, yes.
Thank you.
But in addition, I would say that this engaged the right to privacy as a whole.
Yeah, we've got that point.
Yes. And regarding the court in Mauritius said that we have not been able to establish that it is not justifiable in a democratic society. And this is to be found in my statement of case at page 1045 of.
Well, can you give me the paragraph in your statement of case, because I have it separately?
Paragraph 40 is the top paragraph, actually, at the top. Or at least that's 1045. I'm not quite sure which bit is it. That's right.
Can you help me at the moment?
It is at page 27 of, that is appellate's case,
Yep.
paragraph 74.
Right.
Appellate's case, paragraph 74. I'm sorry, madam.
In the few minutes before the short adjournment,
Yes.
let's try and sort out a purely legal point.
Yes.
It relates to the bit at the end of section 9.2.
That's fine.
Except so far as that provision, or as the case may be, the thing done under its authority, is shown not to be reasonably justifiable in a democratic society. The Supreme Court said that the onus was on you
Yes, madam.
to prove that it wasn't reasonably justifiable. It said that at page 872, 10 lines down from the top.
Yes, madam.
You say in paragraph 76 of your case, and we've got it open,
Yes, madam.
that the Supreme Court was wrong to conclude that there's an onus on the appellant and that you'd failed to establish ... So let's deal with the onus of proof point. Speaking for myself, my recollection of analogous provisions under the European Convention is indeed that the onus wouldn't be on you,
Yes.
but would be on the government
Yes.
to establish reasonable justifiability. But your problem is it not, the wording of the exception, which says, except so far as that provision is shown not to be reasonably justifiable. So what are you going to say to us about the onus of proof in those circumstances?
I don't, we have to rely on the decision of MARPA.
What about reading the Constitution? I mean, if you read the Constitution,
That is-
the onus is plainly on you.
I would
It doesn't
say
matter
that
anyway.
Maybe it doesn't matter.
Which is the decision you say you rely on? Which is the decision? I didn't catch the name.
Marper.
Marper.
S and Barper. It's the 2009 decision.
That's on the rather different wording
It's
of
a
the European
leading
Convention.
case on the right to privacy, where two persons were arrested, a case was dropped and dismissed, and following that they applied to have their data destroyed in purely criminal context.
Right.
And this case went through all stages: trial, appeal, House of Lords with due deference, and then ended before
But the language
European,
of the convention was different.
yes, under the European Convention. And it was considered that it is for the court to see, that is, it is for the national authorities. And here I am reading at paragraph 75 of my statement of case, citing the decision in S versus UK at paragraph 101 and 102. That is,
Where
It would be-
do we see the text of the convention?
it would be the text of the European Convention to be found at
It's very early on. It's tab 2.
tab 2. At page 1117.
Thank you.
Yes,
Which we are
where
submitting.
8.2 suggests that the onus would be on the government to show that it was necessary in a democratic society in the specified interests
Yeah.
that they're stated.
But can I just slightly extend the question? You did succeed in part, or you must have succeeded in part, even if the onus was on you, of satisfying it to the extent that the Supreme Court held that the arrangements for storage and retention of fingerprints and other data were unconstitutional. And I think you make the point that there is an oddity in their holding, firstly, that the law providing for storage and retention was a permissible derogation under Section 9.2, and then holding that there was a breach of Section 9.2. But that's a slightly technical point, isn't it? Because I think it's clear enough what the drift of their thinking was. They were suggesting that in principle a law of this nature with sufficient safeguards would be admissible, but that there weren't sufficient safeguards of a specific type, judicial protection and control or review. Isn't that what the analysis? We could deal with that point.
I think this is the proper analysis,
Yeah.
and this is along the same line as Marper versus
Yeah.
S versus
Yeah.
UK, the case of Marper, whether the reasons put forward are enough. In Marper, they put forward the justification of fight against crime and prevention against terrorism. But the court went on to see that the safeguards that were provided were inadequate,
Yes.
and therefore considered it not proportionate. That is, the interference with the right to privacy was not proportionate to what the government's justification put forward. But prior to coming to Marper, on the issue of reasonably justifiable in a democratic society, they have tried to say that it is in the interest of public order. We have no evidence about public disorder, riot, etc. Maybe the court was trying to say public policy, but even though, if the rationale applies for storage, the Supreme Court did not go further to say storage on a database or storage on the chip of the card. And this is why we are at a loss. It is a judgment with due deference, which is neither here nor there, because when we read the concluding paragraph That is the last paragraph of the judgment, the conclusion of the Supreme Court. And this is to be found at the record at page jugement.
Well, the last paragraph, yes, we can read it.
We can see that 4 and 5 and 6 are contradictory.
Yes, well, that's the point I was putting to you, and I think we've sorted it out.
5 and 6 are contradictory. Sometimes the Supreme Court says it is permissible.
No, you've agreed with my analysis, I think.
Yes, well.
Right.
And paragraph 2 also of the conclusion would be contradictory. What is the purpose of recording? Recording would mean to take for future use, recording. Now, if storage is unconstitutional, why record the fingerprints of the citizen? And it is a judgment which, according to my view, is head I lose, tail I do not win.
Right. Well, I think we will adjourn till 2 o'clock and look forward to your further submissions then. And we've got then maximum of an hour.
Is it an appropriate time?
I know you did. Yes.
Yeah.
Good. 2 o'clock. Thank you very much.
Thank you.